Harold considered himself one of the most prepared men in his entire neighborhood. He had a will, drafted by an attorney back when his children were still in high school. He had a trust, set up almost a decade later by a completely different attorney after he sold his business. He had a power of attorney, signed somewhere in between, during a routine appointment he barely remembers today. On paper, Harold had done everything right. He had every document people are told they need. But when Harold passed away, his family discovered something nobody expected. These documents didn't actually agree with each other. His will named one of his sons as executor. His trust named a completely different person as successor trustee. His original will, the one his attorney needed to file with the court, couldn't even be located. Only an old photocopy remained in his files, and in his state, a copy alone wasn't enough to move forward smoothly. Harold didn't have too little planning. In some ways, he actually had too much, scattered across different years, different attorneys, and different chapters of his life, never once reviewed together as a complete, coordinated plan. His family didn't face one single mistake. They faced an entire web of small inconsistencies that together created months of confusion during what should have been a peaceful, respectful transition. Welcome back to Retiree's Guide, the channel built for people who want to protect everything they've worked an entire lifetime to build. If you're new here, take 2 seconds right now and hit that subscribe button, because every single week we walk through exactly these kinds of financial and legal blind spots, the quiet gaps that sit untouched for years until the moment they suddenly matter most. Today, we're pulling the camera back a little further than usual because we've spent time on this channel talking about wills, beneficiary designations, power of attorney, and trusts individually. But today we're talking about something just as important, how all of these pieces are supposed to work together as one coordinated estate plan, and what happens when they quietly don't. If you assume that having a few of the right documents automatically means you're fully protected, what you're about to hear could change the way you think about your entire plan. Here's the first thing to understand, and it's a mistake that affects an enormous number of families, even ones who genuinely did the work to get documents in place. Estate planning isn't really about having individual documents. It's about having a coordinated system where your will, your trust if you have one, your beneficiary designations, and your power of attorney all point in the same direction, reflecting the same wishes, the same people, and the same intentions. The problem is, most people don't create all of these documents at the same time, with the same attorney in the same sitting. They're often created years apart, sometimes by different attorneys entirely, sometimes during completely different chapters of life. A will written during one marriage, a trust updated after a business sale, a power of attorney signed almost as an afterthought during a routine appointment. Each document might be perfectly valid entirely on its own, and yet together they can quietly contradict each other in ways nobody notices until it's far too late to fix. Let's talk about how this kind of contradiction actually shows up in real life, because it's rarely dramatic. It's usually small and easy to overlook. Maybe your will names your oldest child as executor, while your trust names a completely different child as successor trustee, simply because the trust was created years after the will, during a period when your relationship with one child happened to be a little closer than the other. Maybe a beneficiary designation on a retirement account still lists a sibling who has since passed away, while your will, updated more recently, properly reflects your current wishes. Each individual document might look perfectly fine sitting alone, but when your family pulls them all out together after you're gone, these small inconsistencies can create real confusion about who actually has authority, who's truly entitled to what, and which document should take precedence when two of them seem to disagree. This brings us to something incredibly important that most people don't fully understand: the order of priority among these different documents. As we've discussed before on this channel, beneficiary designations on retirement accounts, life insurance policies, and certain bank accounts generally override whatever your will says, regardless of how recently your will was updated. Property held in joint tenancy generally passes directly to the surviving owner, again, regardless of what your will instructs. Assets actually titled in the name of a trust are governed by that trust's terms, not your will. Only assets that don't fall into any of these categories typically pass according to your will at all. This means your will, the document most people consider their primary estate planning tool, might actually control a much smaller portion of your overall estate than you assume, while your account titling and beneficiary forms quietly control the rest. If these pieces aren't reviewed together and kept in alignment, your overall plan can end up working very differently from how you imagine it does. Now let's talk about something incredibly practical and surprisingly common: the simple problem of nobody being able to find your original documents when they're actually needed. Many states require an original will, not a photocopy, to begin the probate process smoothly. If that original document has been lost, misplaced, or simply forgotten in an old filing cabinet nobody remembers, your family may be forced into a more complicated, more expensive legal process just to prove a copy should be honored instead, sometimes requiring additional court hearings and unnecessary delay. The same issue can affect trust documents and powers of attorney as well. It doesn't matter how thoughtfully these documents were drafted if nobody in your family actually knows where to find them, or worse, if the originals themselves have simply been lost somewhere over the years. Let's also talk about something that connects directly to this, and that's failing to tell anyone where your documents are actually kept, or who your attorney even is. Some people keep their estate planning paperwork extremely private, sometimes out of habit, sometimes simply because the topic feels uncomfortable to discuss openly with family. But if something happens to you and no one knows whether a will exists, where it's stored, or which attorney originally prepared it, your family may spend valuable time simply trying to determine whether a plan even exists at all before they can even begin addressing what it actually says. A thoughtful estate plan isn't only about what's written in the documents. It's also about making sure the right people know these documents exist and know exactly how to access them when the time comes. Here's a mistake that's becoming increasingly relevant simply because of how often laws and financial regulations continue to change, and that's assuming an estate plan created years ago automatically still reflects current rules. Estate tax thresholds, retirement account distribution rules, and certain financial regulations have shifted meaningfully over recent years, and plans built around older rules don't automatically update themselves just because time has passed. A strategy that made complete sense under older regulations might not function the same way today, and without periodic review by a knowledgeable professional, families sometimes discover this only after it's already too late to make adjustments. Let's also talk about a mistake that's less about paperwork and more about people. And that's never building a coordinated team to help manage your estate plan as one connected whole. Many people work with an attorney for their will, a separate financial advisor for their investments, and sometimes a different professional entirely for tax planning, without these professionals ever actually communicating with each other about how all these pieces fit together. Your attorney may not know exactly how your retirement accounts are titled. Your financial advisor may not know the specific details written into your trust. This lack of communication between professionals can create exactly the kind of quiet gaps we've been talking about throughout this video, gaps that nobody individually responsible for one piece of your plan would necessarily catch on their own. Now I want to address something a little less technical and a little more human, because estate planning isn't only about money and property, it's also about making things genuinely easier for the people you love during one of the hardest moments of their lives. This is where something called a letter of instruction can make an enormous difference, separate entirely from your formal legal documents. This isn't a legal document itself, but rather a simple, informal letter explaining practical details your family will need, where important paperwork is kept, contact information for your attorney and financial advisor, instructions or preferences regarding your funeral or memorial service, and even guidance on smaller personal matters, like who you'd like to receive specific sentimental items that might not be formally addressed anywhere else. Families often spend an enormous amount of emotional energy simply trying to figure out these everyday practical details during an already overwhelming time, and a simple letter like this can remove a significant amount of that unnecessary stress. Let's talk about another mistake that connects directly to something we've discussed before on this channel. Treating your estate plan as something that only matters after you pass away, rather than something that also needs to function properly while you're still alive, but unable to make decisions for yourself. A complete estate plan isn't only about your will or your trust. It also includes your power of attorney and your healthcare directive, documents that allow your family to step in and help you during your lifetime if illness or injury ever makes that necessary. Some people focus heavily on what happens after death, while leaving these incapacity-related documents outdated, incomplete, or missing entirely. A truly coordinated estate plan protects you during every chapter, not only the very last one. It's also worth addressing how something as simple as inconsistent personal information across different documents can create unnecessary complications. Maybe you signed one document using your full legal name, another using a nickname or a maiden name from years earlier, and another using a slightly different address than where you currently live. These might feel like meaningless technical details, but financial institutions and courts often require consistency, and discrepancies like these can sometimes slow down or complicate what should otherwise be a straightforward process. Taking the time to ensure your name, address, and other identifying details match consistently across every single document is a small detail that can prevent unnecessary friction later. Let's talk about something that connects estate planning directly to a topic many retirees worry about separately, and that's long-term care. Many people build a thoughtful estate plan focused entirely on how assets will eventually be distributed, without fully considering how the cost of long-term care, whether at home or in a facility, could significantly reduce those very same assets long before any distribution ever takes place. This doesn't mean every estate plan needs to become a long-term care plan as well, but it does mean these two areas of planning genuinely benefit from being considered together, rather than as two completely separate conversations happening in isolation from one another. Let's also talk about something that's become increasingly relevant simply because of how much of our financial lives now exist online, and that's the idea of a digital executor, someone specifically responsible for handling your online accounts, email, social media, and digital financial platforms after you're gone. Many estate plans were written before this was even a meaningful consideration, focusing entirely on physical property and traditional financial accounts. Without clear instructions and a way for your family to actually access these digital accounts, whether through a password manager, specific legal authority, or clear written instructions, valuable information, photographs, and even financial assets can become permanently locked away behind login screens nobody else can access. This is exactly the kind of gap that a periodic review can catch, simply by asking whether your current plan accounts for the digital side of your life, not just the physical and traditional financial side. It's also worth taking a closer look specifically at life insurance policies and retirement accounts during this kind of comprehensive review, since these accounts are so often overlooked simply because they don't feel like part of your formal estate plan the way a will or trust does. Many people review their will every so often without ever picking up the phone to confirm who's actually listed as the beneficiary on a life insurance policy purchased decades earlier, or an old retirement account from a job left long ago. These accounts deserve the exact same level of attention as your primary legal documents, since, as we've discussed throughout this video, they often control significantly more of your overall estate than people initially realize. So let's talk about what you can actually do, starting this week, to bring all of these pieces together into one coordinated, functioning plan. The first step is gathering every estate planning document you currently have: your will, your trust if you have one, your power of attorney, your healthcare directive, and a list of every beneficiary designation across your accounts, and laying them all out together in one place rather than reviewing each one separately in isolation. The second step is checking these documents against each other specifically for consistency. Do they name the same people in similar roles, or do they quietly contradict one another the way Harold's documents did? Are your beneficiary designations actually aligned with what your will and trust intend, or are they still reflecting decisions made years or even decades earlier? The third step is confirming exactly where your original documents are physically located and making sure at least one trusted family member, along with your attorney, knows precisely where to find them when needed. If you're not entirely sure where your original will currently is, this is worth resolving directly and soon, rather than assuming it will somehow turn up when it's actually needed. The fourth step is scheduling a comprehensive review with a qualified estate planning attorney, ideally one who can look at your entire plan as a whole, rather than focusing on just one document at a time. This is especially important if your different documents were created by different attorneys across different years, since nobody may have ever actually reviewed the complete picture together until now. And the fifth step, one that costs nothing but a little time and a little courage, is having an honest conversation with your family about your overall plan. You don't need to disclose every specific financial detail if that feels uncomfortable, but making sure your loved ones understand the general shape of your wishes, where to find important documents, and who to contact when the time comes, removes an enormous amount of unnecessary stress and confusion during an already difficult period. There's one more habit worth building into your approach going forward, and that's treating this kind of comprehensive review as something you do on a regular schedule, rather than only when a major life event forces your hand. Some financial advisors suggest reviewing your complete estate plan roughly every 3 to 5 years, or sooner if anything significant changes: a move, a marriage, a divorce, the birth of a grandchild, or the loss of someone named within your documents. Treating this the way you might treat a regular medical checkup, something scheduled proactively rather than reactively, makes it far less likely that small inconsistencies have the chance to quietly accumulate over many years, the way they did within Harold's set of documents. It's also worth considering what happens if the attorney who originally drafted your documents has since retired, changed firms, or is no longer practicing at all. Estate planning documents don't expire simply because the person who wrote them is no longer professionally available. But if questions ever arise about original intent, having a current relationship with an attorney familiar with your situation, rather than tracking down someone from decades ago, can make any future updates or clarifications significantly smoother for your family. I know this might feel like a lot to take in all at once, especially after we've covered so many individual pieces of this topic in earlier videos. If you're feeling a little overwhelmed right now, please know that's a completely normal reaction. Most families have at least a few of these small inconsistencies sitting quietly in their own paperwork without even realizing it. You don't need to fix everything today. Start with one simple step, gathering your documents together in one place, and move forward from there at whatever pace feels manageable to you. It's worth pausing here to recognize something important about everything we've covered today. None of these individual gaps are particularly dramatic on their own. A forgotten beneficiary form, a misplaced original document, a successor trustee who's no longer available. Any single one of these by itself might never cause a real problem. What makes a complete estate plan vulnerable isn't usually one major failure, it's the slow, quiet accumulation of several small oversights, each one easy to overlook individually, that only reveal themselves together, all at once, during the exact moment your family can least afford additional confusion or delay. This is precisely why a comprehensive review, looking at everything together rather than one piece at a time, matters so much more than people often realize. Let me share one more story before we close, because it shows how this kind of coordinated review can make a genuine difference when it actually happens. Consider a woman named Eleanor, who, after watching a video very similar to this one, decided to gather every estate planning document she had into a single folder for the very first time in years. Sitting down with her daughter one weekend, she realized her trust still named a sister who had passed away nearly a decade earlier as a backup trustee, with no one else listed to step in after that. She also discovered an old retirement account from a job she'd left decades ago still listed her former husband as the sole beneficiary, despite having been divorced and remarried for over 15 years. Neither of these issues had ever caused a problem yet, simply because nothing had required anyone to actually use these documents until that point. Eleanor spent one single afternoon making a list of corrections, then spent the following weeks meeting with an attorney to properly update everything at once. She didn't fix these issues because something had already gone wrong. She fixed them because she finally took the time to look closely enough to notice they existed in the first place, long before her family would have ever discovered them the hard way. Stories like Eleanor's and Harold's show two very different outcomes from the exact same underlying situation. Documents created at different times, in different chapters of life, never fully reviewed together as a whole. One family discovered these gaps too late, during an already painful time, while the other discovered them early enough to quietly fix everything without any crisis at all. The difference wasn't about how much money either family had, or how complicated their situation was. It was simply about whether someone took the time to look at the complete picture before it became urgent. If something in this video gave you a moment of clarity today, scroll down right now and leave a comment letting me know whether you've ever reviewed all of your estate planning documents together at the same time, or whether, like so many people, you've only ever looked at them one at a time, years apart from each other. I read every single comment, and so many of the most valuable conversations on this channel begin exactly there, with someone sharing their own experience or asking a question that ends up helping everyone else watching too. And if you know someone, a sibling, a close friend, a fellow retiree, who might benefit from hearing exactly this today, please take a moment and share this video with them. Sometimes the most caring thing we can do for someone we love isn't a grand gesture. It's simply making sure they have the right information before a small, quiet gap in their planning ever becomes a real problem for their family. Before you go, make sure you're subscribed to Retire's Guide, because we still have more important pieces of this conversation ahead of us, including a closer look at how recent shifts in financial regulations and tax rules could be quietly affecting plans that haven't been reviewed in several years. We'll be walking through exactly what's changed and what it might mean for your own situation very soon, and it's something every single person watching today is going to want to understand clearly before it potentially affects their own family. Stay close, stay informed, and thank you so much for spending this time with us today. We'll see you in the next one.